Good morning and assalamu alaikum to all of you. Thank you, Hassan, for this generous introduction, and thank you all for attending. I'm going to do something. I'm going to share my screen and show you my PowerPoint presentation, because this might make things easier with regards to some of the points I want to raise. Okay, so first of all, thank you for inviting me to talk about this book. It's been a decade now that I have. Somebody raises their hands. Any problem? Can you see what I'm?
Professor Shamsy, you're good to go. Yes, no worries.
Yeah. Okay. All right. So it's been a decade that I've published this book. This book developed out of my dissertation that I completed in 2009, and then I worked on this thesis for another 4 years, or for another few years before it was then published in 2013. And let me kind of start by giving you an idea of how I'm approaching this question, and let me start by starting with the thought experiment. All right, so let's start not in the second Hijri century that my book starts, but let's start at the very beginning of Islam. Let's start during the lifetime of the Prophet Muhammad, or just after his life. If you are living, let's say, in Medina, and you have a question, a very simple question, let's say, about how you pray, or a more complex question about how you deal in business, in buying and selling, etc. What do you do? Do you go to the library and buy a book on Islamic law, or check out a book? No, obviously you're not. There's no libraries. But how do you access Islamic law? What exactly do we mean by Islamic law? I think the most reasonable approach to this is to think that if you live in the early Muslim community, you have a very strong sense of there being a religious tradition, i.e., there's a lived tradition. There are the Muslim community is intact, right? So we're not talking about a religious tradition, let's say, like Christianity, that is in which the founder does not found a self-regulating or an autonomous community, but in Islam we have this. We have caliphs, we have successors, we have states that are based on Islam. We have people who knew the Prophet who survive. So Islamic law is to a large extent a tradition, a lived tradition, in which you learn from others, and rather than think of it as a textual tradition at the beginning, right? So we would not expect to if a question comes up in let's say in the year 15 of the Hijrah, that people sit down and consult texts somehow, but that this is that there are I mean in the year 15 we don't even have a codified text of the Quran. Of course, that happens during the Caliphate of Uthman, but even that text is primarily remembered, right, memorized. But certainly we have no texts of Islamic law at this point, and we have no text of Islamic law until the 2nd century, so until about 100 years after the Prophet Muhammad's death. And really one of the first texts that we have is the Muwatta of Malik ibn Anas. So we have this large time period in which we don't have texts, in which we have to kind of imagine what Islamic law looked like. And part of this, what I want to do in this talk is kind of give you a little bit of a sense of how Islamic law looked like before it was written down, and then what happened when it was written down to this body of ideas. So this is an important point. The differentiation between orality and writing. That this makes a big difference in an intellectual exchange, whether you do this orally or in written form. So a simple example of this is, if you don't have books, you have to consult people in person, right? So you have to consult their teaching circles. You know, if you want to study the rules of let's say of purity, you have to sit with a scholar and learn from this scholar. And if you have questions, you have to ask those questions orally. And if you know anything about you know, your experiences with studying, there is a lot of things that you do differently in oral instruction, right? You don't have footnotes. It is there's very much a kind of a rhetorical dimension to it. Let's say if you go to a lecture of a great sheikh and you have a specific question, it might be not as easy to ask. So what exactly was your reasoning at this specific point? Can we go back 2 pages? You know, it is a different thing to engage in legal reasoning, to learn if you are dealing with an oral tradition. Part of this is a fact of just material culture. You know, in the early about century of Islam, you have very primitive writing materials. If you learn about the early companions writing down the Quran, and when the Quran then was under the caliphate of Uthman collected, the Quran was written down on very simple materials, on stones, on slabs of stones, on the shoulder blades of camels, on palm leaves. So you might be wondering, why weren't they writing this down on paper? Well, paper wasn't known in the Arabian Peninsula during the time of Islam, and in fact took about a century and a bit for paper to be brought in from Central Asia to be adopted. It was only adopted in the Abbasid era. In fact, during the lifetime of Shafi'i that I'm going to talk about today. So it is, you know, kind of basic writing material and books were very rare things. So most of the instruction took place in written form, and scholars generally didn't debate over writing. We have a few rasail, we have a few letter exchanges between scholars that begin in the 2nd century, really. But they clearly didn't have, you know, long letters they were writing to each other. These are relatively short, still a couple of paragraphs each, because they just didn't have easy writing materials such as paper at this time and place. So one of the first scholarly letter exchanges that we have about Islamic law is a letter exchange between Al-Layth ibn Sa'd in Egypt and Malik ibn Anas in Medina. And so this is an exchange that probably took place sometimes, you know, maybe in the, you know, around the year 150 of the Hijrah, in which Al-Layth and Malik discuss several points of law, and one of them is the question of local legal traditions. And so this is Al-Layth ibn Sa'd here making the point that the Sahaba, the contemporaries of the Prophet Muhammad, they spread out in the world, right? They didn't all stay in Medina. They spread out. They settled in the newly conquered territories, and there they established communities, right? And people learned from them. Muslims learned religion from them. They taught this religion, and so what he's basically strongly implying and explicitly saying is that each of these local Islamic traditions are authentic because they were founded by companions of the Prophet Muhammad. So, you know, he's obviously speaking as an Egyptian. You had the Sahaba settling in in Egypt, Amr ibn al-As, for example, Amr ibn al-As, and in different places, Iraq, obviously Syria, other places where Sahaba settled. So this is an argument for these local traditions being authentic. They are all based on authentic knowledge, but at the same time, there's an admission there that these traditions aren't always fully of the same opinion. And this is creating problems. So, for example, in Egypt, one of the kind of well-known differences between Egypt and Iraq at this time period is that in Egypt, you during prayers, you pronounce the basmala aloud, right? You pronounce the basmala aloud, while in Iraq, you pronounce it silently. You might say maybe that's not such a big deal, but it's a very visual, it's a very obvious difference, right? If you participate in prayers and the very beginning of prayer is very different between one place and the other, and then the question comes up, so which one is right? Or are both of them right? And so Al-Layth is making the argument that all of these local traditions are legitimate, while in this letter exchange, Malik ibn Anas makes the opposite argument, and he makes the argument that Medina has a specific authority, and people should follow the example of Medina. Now, how do people deal with the development of law? One important point to keep in mind here is this idea of ra'i, i.e., a way of legal thought that allows jurists to extend the law. Because I mean, even if we were to take the Quran and the sayings of the Prophet, and even the example of early authorities, there are just cases that they didn't cover, right? And so what to do about them? And one example I give in the book, and that's kind of, I think, illustrative, is the question of ghasb, right? So if somebody let's say you have in your front yard, you have a shovel that you use for working in your garden, and somebody comes along and takes the shovel. In Islamic law, that's not considered to be theft. If the shovel was just lying outside, it's considered to be ghasb, and sometimes translated as misappropriation. Now, what is the legal ruling for ghasb? Is the person has to return the thing that he has taken from you. That's very simple. It's based on everybody agrees on that specific ruling. But then, if we push this just a little bit further, things become less clear. So, what if instead of taking a shovel, this person took a log, a piece of wood from my front yard, and then took it home and then built a house with it? Like, he took many pieces of wood, among them one of them that he took from me, and he builds a house. Now, if you then go to him and say, well, give me back the log, he might say, well, if I take away the log, then I'm actually destroying the whole house. So it's not just that I'm returning to you the value that I took from you, but in fact, I'm destroying my own property. So does this person still have to return this specific log? Or, that's a different opinion, in this case, does he just have to return to you the value of the log, because otherwise he's actually incurring damages that are kind of unreasonable? So you can see here there is ways of extending a known position and then getting to the kind of edge cases where it's not as clear anymore whether the original rule applies or whether we now have to come up with a rule that's slightly different because the circumstances are different. So ra'i is a way of kind of pushing known rules into extremes and then seeing what happens and how they interact with other rules. So, for example, I mean, the other rule that it's this law of ghasb is kind of is pushing against is the idea that that you don't cause financial harms to others for no reason, right? And the place that was most well known for this way of legal thinking was Iraq, right? So the Ahl al-Ra'i, the kind of jurists and the kind of people who would eventually particularly be known as the Hanafis, that was Iraq, in which people like Abu Hanifa and his students were engaging in this type of systematic extension of the known legal rules. Another problem that was plaguing the Muslim community in this specific time period is the fact that law is obviously not just personal, individual, but it is in fact communal, and it is of interest to the state. So we have here, this is a quote by Ibn al-Muqaffa, who was very early Abbasid era bureaucrat, who wrote, it's not clear to which of the early Abbasid caliphs, but to one of the early Abbasid caliphs, about what he saw to be the problem of unpredictability, which is if every judge is able to derive the law by themselves, right? If every judge is basically a mujtahid who comes up with rulings, then you don't have predictability. If my court comes to a different conclusion than the court, 5 miles down the road, people will become confused. So is there no single law? Is everybody, depending on which judge you go to, you get a different ruling? That's a negative thing. Right? States don't want that. States want to have a predictable law across the land, right? If you go to Chicago or to Washington or to Los Angeles, you have the same law because the same law governs the land. And so we have historically seen Muslim rulers trying to establish some sort of predictability, and so one of the initiatives that we hear about in the early Abbasid period is that I think most of the reports talk about Al-Mansur approaching Abu Hanifa, approaching Malik ibn Anas and asking him to write a authoritative work on Islamic law that would then be applied throughout the realm, right? There is speculation what the connection is between Al-Mansur asking Malik ibn Anas this and Malik writing his Muwatta. But as far as we know, this was not. I mean, Malik in fact rejected this idea, but at the same time he did write the Muwatta, and the Muwatta is one of the earliest books of Islamic law. So that there is a point at in the it's probably 140s of the Hijrah, in which we see the beginning of Islamic legal texts that still exist today and that were taught and that became spread throughout the Muslim world. So we can see a movement from an oral legal tradition towards a written legal tradition, and that takes place within these discussions of kind of universalizing Islamic law throughout the realm. Now, when we speak about Islamic law, what exactly do we expect? One of the quotes that Malik ibn Anas himself liked a lot. Oh, I'm sorry, I see there's some problems with the script on the slide. One of the traditions that Malik ibn Anas liked was from Umar ibn Abdul Aziz, the Umayyad Caliph, who ruled very shortly, about 18 months, around the year 100 of the Hijrah, in which Umar ibn Abdul Aziz said, the Prophet and the holders of authority, the Wulat al-Amr, after him, established traditions, sunan, right? So here, sunan is not just limited to sayings of the Prophet Muhammad, but he uses them both to apply to the Prophet and and kind of righteous holders of authority after him. They established sunan. To adhere to them means conforming to the book of God. Whoever seeks guidance from them will be guided. Whoever seeks success through them will be successful. And whoever contravenes them follows a path other than that of the believers. So this here is it's an interesting quote, because it shows that for him, this normativity is a continuing thing. It's not just something that you can just that is just embodied in sayings and actions of the Prophet, but that also continues through other authorities after him. And that is actually very much the idea of law that we find in the Muwatta itself. So this is here on the right hand side. You see probably the oldest surviving fragment of the Muwatta. This was written maybe during Malik's lifetime or just shortly after them. We only have like 2 pages of this version, but this is not just probably one of the earliest texts of Islamic law, but really the earliest bestseller in Islamic law. So we know of hundreds of people who studied with Malik, who studied this text with Malik, and they really carried this text into all corners of the Muslim world, from Al-Andalus up into to Khorasan during his lifetime. So this was a text that is early, but was really taken up very early by a lot of people. This is the name of this text, Al-Muwatta, the well-trodden path, says a lot about what Malik thought about what he was writing down. There's this famous statement that Malik makes in his letter to Layth ibn Sa'd, "An-nasu taba'un li ahl al-Medina." Everyone ought to follow the people of Medina. So he has a sense that the legal tradition of Medina is normative, not just for people in Medina, but it is really normative for everybody. Everybody should follow it, and that's why he's writing this book. Now, the question of, excuse me. The question of what he's doing in this work is quite interesting. Because as I've mentioned before, Malik's idea of law is a idea of a tradition that continues into his own time. So it is not just that he does cite the Quran, he does cite hadith, he does cite opinions of the Sahaba, but these are not in themselves authoritative. He sometimes cites an early, it might be hadith or it might be an early saying, but then he says, well, the amal is not according to this, but it's according to something else, right? So this is from today's perspective, this might be confusing, and I'll come back to this later on when I talk about Shafi'i's critique of Malik ibn Anas. But there is a sense of a Medinan tradition that shows you the right path. It's the well-trodden path, right? You don't have to make your own path, find your own path. There's a well-trodden path. You can follow this, and this local tradition shows everybody what they should do. And a lot of people were enamored with this approach and took this up. But what I want to talk about is the development of critiques to this approach, and I'll talk about this in a moment. The other notable current in Islamic legal thinking at the time took place in Iraq. I've mentioned this before, the jurists in Iraq, and what I do in this book is I follow a Shafi'i who was a man who grew up in the Hijaz, who studied with Malik ibn Anas in his in his later teens, mid-teens. And then afterwards, after he had studied with Malik, he moves to Iraq. And what he encounters there is a different local tradition, right? The Iraqis have their own local tradition. They have their own local precedents that they draw on, Ibn Mas'ud, for example. But another intellectual current that people have to deal with at this point is that you have hadith scholars traveling throughout the Muslim world and starting to systematically collect hadith and writing them down and then going around teaching these hadith. Now, what this does is it creates a challenge to local legal traditions, right? So you have a local legal tradition. Let's say, I mentioned this before in Egypt, that you pronounce the Basmala at the beginning of Surah Al-Fatiha, the Bismillah ar-Rahman ar-Rahim. In prayer, you pronounce that aloud. Now, let's say you have somebody who comes into Egypt and says, okay, I've studied all these hadith. Here is a hadith about the Basmala not being part of Surah Al-Fatiha, with the suggestion that means that you don't pronounce it aloud in prayer. So what do you do at this moment? You have a local tradition. Everybody who's alive remembers, from the first time they prayed in the central mosque, that you pronounce the Basmala aloud. And then one person is coming from somewhere else who transmits a hadith from the Prophet that says that the Basmala is not part of the Fatiha and therefore should not be pronounced aloud. What do? Do you take this transmission from this single person who has come to you, or do you say, okay, we have this local tradition. For all we know, it started with the Sahaba, because who would have changed it, right? I mean, if the Sahaba started, it would have been if they had recited it quietly, who would have started changing that? This is probably it's authentic because it's so obvious, right? It's not like something that people do in their houses secretly, but it's like one of the most in the central place of communal life, the Friday mosque. That's where it has been continuously performed, prayer, right? So what do you do at this point? What do you do with these new traditions that are coming in, that are circulating, and that sometimes don't square well with the local legal tradition? So when Shafi'i goes to Iraq, he encounters ideas, for example, by somebody like Abu Yusuf. He doesn't actually meet Abu Yusuf himself, but he encounters Abu Yusuf's writings, who says in his writings that the number of available hadith has increased greatly. And then he says, Abu Yusuf says, those reports are to be excluded that are unknown or not known to the jurists, as well as those that agree with neither the Quran nor the Sunnah. And beware of irregular hadith, and keep to those hadith to which the community adheres and which the jurists know. Okay, so what is Abu Yusuf suggesting here? He doesn't suggest we don't care about hadith. He doesn't say anything like this. No, of course, the local tradition, the Iraqi local tradition also has a hadith, and it also has reports of earlier authorities. It has reports going back to the Prophet Muhammad, but it's a limited corpus of reports. And what he says is, we're not going to, we have a coherent body of laws developed in our local tradition. We're not going to start to disassemble it just because individual irregular shadh reports are brought by these hadith scholars, right? So these have to be we only accept the hadith that our jurists have been working on and have accepted for a long time. That's normative for us. These other hadith, we just don't care about them, right? And he also says that that we reject those hadith that don't agree with the Quran or the Sunnah. That's interesting, right? So we apply a test whether a hadith works with the Quran, and if it doesn't, we disregard it. Let me give you an example. It says in the Quran, prayer is prescribed to you in specific times. Yeah, Now, there are hadith that say that. So, what this verse in the Quran suggests is that prayers have to be prayed within specific time periods. Now, we do have hadith that when the Prophet traveled, that he combined prayers, right? So that, for example, you pray the Dhuhr and the Asr prayer in the time of, let's say, Asr. So you don't pray Dhuhr in the time of Dhuhr, but you pray it in the Asr time slot, right? So what the Hanafis at this point said about this hadith, saying, yeah, we don't accept this hadith because it goes against the statement of the Quran. The statement of the Quran is we pray prayers in specific time slots, right? So this was one of the arguments to exclude hadith from their considerations. Another one, this is the example I give on this slide, is a very important. So they accept an important hadith, al-kharaj bid-daman. Profit comes from liability, meaning you are entitled to profit in a business venture if you carry liability in it, right? So to put it the other way around, you're not entitled if you don't carry any risk, right? So this is, for example, this covers issues such as riba, right? If you're guaranteed to get this money paid back, then you're not carrying any risk, so therefore you're not liable to profit. Now, what this does is it creates tension with another hadith, right? With a less known hadith, which is the case that if you buy, so this hadith says that when people bought a cow, right, a female cow, and then after a while found out that it had a defect, which means that you could return the cow to the buyer, which is a basic rule, right? If you find a defect after the sale, you can return it. What happens if you milked the cow while the cow was in your possession? Yeah. If you take this principle, profit comes from liability, you say, okay, you were entitled to this profit, to the milk of the cow, because you were liable for this cow. If the cow had died while it was with you, you couldn't have returned it. You couldn't have returned the carcass of the cow and say, I want the money back. No, you were liable for the cow, so you were entitled to the profit, to the milk. Great, right? Solves the problem nicely. The problem is, in the hadith, the Prophet Muhammad said, in this case, when you return this cow after you've milked it, you should give the original seller an amount of dates basically as payment for the milk that you've taken from this person, right? Now, that doesn't work with this principle, al-kharaj bid-daman. So what the Hanafis said, well, we stick with this hadith, al-kharaj bid-daman, profit comes from liability, and we just disregard this other hadith about having to basically pay a certain amount of dates to somebody whose cow you milked while having it. Now, this is something that it's consistent, it's intellectually consistent, but it's also something that really upset a Shafi'i, because what a Shafi'i said is, you are actually disregarding statements by the Prophet Muhammad. That's a problem, right? That's if you're so much into your own legal thought that you feel fine to disregard hadith, then there's something wrong with your methodology. So what he said here is like for this specific example of the profit and liability case, is that he said that that the reason, I mean, he doesn't just say, well, we just have to adhere to any hadith that come to us, but he says that in fact these two hadiths work very well together. They're not in contradiction, as the Hanafis claim, and the reason why they're not in contradiction is that what you do when you return the cow is you are meant to return the whole value of the cow, right? So, if you buy a car and then you return the car after 5 days because there's a problem with it, you can't take out, the spare wheel, for example, and keep that for yourself. No, you have to return the whole cow. What you did was, when you bought the cow, you bought the milk and the udder, right, as well. And if you then milk it, you're actually diminishing the value of the cow that you're returning. So the dates that you're paying is just to make sure that what you return has the same value than what you got. So he says there is no contradiction. In fact, it works perfectly together, these two hadith, right? So we can see here that there is a kind of high-level both legal thought going on, but also kind of methodological thought. So how do all these different sources of the law work together, and how can we consistently think about which are the sources of the law and which are not sources of the law? And so the Hanafis have developed a way of including some hadith while excluding others, while a Shafi'i really wants to become a maximalist who says, no, we accept all hadith. Okay. Now, a second really important insight into this theorization of hadith with the Shafi'i and Abu Hanifa students is a case that again we find in the literature on the question of theft. And so if you look at the Quran says it talks about cutting the hand of the thief. All right. So you cut the hand of the thief, which the Khawarij, right? Khawarij. If some of you don't know who the Khawarij are, I can talk about this in the Q&A. But the Khawarij, they just took that verse and say, anybody who is a thief, you can cut their hands. Now the problem is, of course, that there are a lot of hadith that talk about a very specific conditions for what qualifies as theft, right? So it has to be in a basically locked place, and it has to reach a certain value before you would apply this punishment. So the Khawarij said, no, we just take anybody who we can call a thief, we just punish as a thief, while basically all the Sunni schools of law say, no, there are all these other qualifications. But all these other qualifications come from hadith. So Shaybani, who was another student of Abu Hanifa, in a debate with a Shafi'i, a Shafi'i pushes a Shaybani and says, so how do you justify yourself in accepting these limitations by hadith? Aren't you saying that, if a hadith clashes with the Quran, you forget about the hadith? And Shaybani says, no, because in this case, the Sunnah explicates, it explains the divine intention behind this verse. So when God said, cut the hand of the thief, what the Sunnah does is, what the Sunnah who says that says it has to be a specific value, a limit of value that it has to have before that punishment becomes obligatory. That explains what God meant in this verse, right? So Shafi'i says, oh, that's a really nice explanation, but why don't you apply this for every hadith? Why do you use this for some hadith, while then, for example, as in the case with the prophet and the cow, or in the case with combining prayers, why don't you do that in those instances? Right? So what a Shafi'i here is pushing for is a consistent usage of hadith in legal thought. Now the next one, the next point to understand in the development of a Shafi'i's ideas about law and why it became so influential and powerful is that he took a kind of an everyday experience that we have of law and made that into a big methodological statement. And so the everyday experience is that for prayer, you have to direct yourself towards the Kaaba, right? Now, the problem is that if you are in and around the Haram, you know where the Kaaba is, right? So if you're standing and you're seeing the Kaaba, you have absolute knowledge, you know which direction to pray at. But at 99.9999% of places on this planet, you don't 100% know for certain where the Kaaba is. you know for certain that you have to pray towards the Kaaba, but you're not 100% certain that you're actually hitting it, right? That you're actually, you're actually exactly facing it. And so for Shafi'i, this is the perfect metaphor for Muslims with regards to Islamic law. We know for certain that we have to direct yourself towards something, but we don't exactly know whether we hit it or not. And that's for him ijtihad, right? So you have to do ijtihad to find the qibla. So that ijtihad is, you might have to look at the stars. You might have to, figure it out anyway, directions of wind or geography or whatever you do if you don't have a compass or a smartphone these days, to find the direction of the qibla. So that's your ijtihad. You're taking all the different signs, right? The dalils, the dalail. You have to put them all together and then come up with your best judgment of where the qibla lies. And he says that is the same thing for law. And so you are obligated to do this. And he says there's a parallel here. Like if you are with somebody else and they do the same and they come up that, they have to pray this way, and you do your ijtihad and you have to actually, and according to your ijtihad, it's actually the other direction. You have to follow your own ijtihad, right? You can't just say, oh, okay, this guy, I'll just follow this guy, taqleed, right? So you can't do taqleed. You have to do your own ijtihad and you have to follow that. Otherwise, your prayer is invalid, right? So this is it's a very powerful image to take, that there is an individual responsibility of finding what the law says. And that's obviously totally different from this communal idea. The communal idea is you don't have to worry. You live in a specific place. People have done certain thing. Everybody does it. Everybody agrees upon it. Then you don't have to worry about it. Right? Like if you go into your local mosque, you're not going to start calculating what the direction of the qibla is. You just look at where is the qibla, and you just pray according to that. Right? There's a local tradition. You just accept it. So a Shafi'i is kind of radically individualistic. No, you are obligated to find out which direction to pray in. Right? So it is revolutionary in that sense. Right? But what I hopefully will explain, it is also something that really hits a nerve in the specific time in which a Shafi'i lives. When a Shafi'i leaves Iraq, he moves to Egypt, and that's where where he writes most of his books. That's where he gets most of his students that would carry on his legacy, and that's also where he would eventually, where he would eventually die. And we have debates that he carried out in Cairo, and this is one that is really, in my mind, really brings out why he broke with Malik's theory of amal, right? Practice, local practice, practice of Medina. And this, to just give you this example, this is about a specific question, right? So if you have if an escaped slave is guilty of theft, what is the punishment of the slave, and who is permitted to carry out the punishment, right? So does the slave has his hand amputated, and can the owner carry out this punishment? Now, what a Shafi'i points out in this, I hope it's not too complicated for you, is that there is the Medinan, it's basically the opinion of Malik that he justifies as being this is Medinan practice, but this Medinan practice is neither the opinion of Ibn Umar, Abdullah ibn Umar, the son of Umar ibn al-Khattab, nor is it the opinion of the local governor, of Medina. It is like it's a hodgepodge mixture of both of them, right? So what he's asking, what he's asking here, and you can even feel his rising anger. So I cannot comprehend what you mean when you say practice, nor do you seem to know it yourself according to what you have told me. I'm forced to conclude that you simply call your own opinions practice and consensus, right? So he says you cannot, you're not deriving your opinions from a specific way of using sources. You're just like, okay, Ibn Umar said this, the governor said this, I take part of Ibn Umar's opinion, I take part of the governor's opinion, and that is our practice. So basically we just have to follow you, or we just have to follow what you say the Medinan practice is. Is that consistent? Is that defensible? Right? It might be defensible if as it was the case with Malik ibn Anas, if you're the most respected scholar in Medina, right, and people come to Medina, the city of the Prophet, and they study with you, and you are this great authority, you have this charisma, right? You're this charismatic authority, this man who still studied with Nafi'. Nafi' was the freed slave of Ibn Umar, right? So you have a connection, Nafi', Ibn Umar, the Prophet, right? So you have a very short isnad and whatever. Maybe people follow you then, but is it actually, if you write it down and you think about it, is it actually convincing you? What exactly is the methodology that you followed in this? Right? Is there a methodology that I could reconstruct in my head? And the Shafi'i says I can't, right? So I'm not going to follow it. Now, what a Shafi'i does instead, what he proposes instead, is a clear hierarchy of sources, right? So he says here, this is from his Kitab al-Umm, law consists of numerous layers. The first is the Quran and the Sunnah, provided that the Sunnah is accurately transmitted. The second is consensus with regard to issues on which the Quran and the Sunnah are silent. The third is what some companions of the Prophet have said, if we know of no other companions who contradict them. The fourth is the opinion that we disputed among the companions. The fifth is analogy on one of the previous layers. When the Quran and the Sunnah are present, no other layer is consulted, and law is derived from the highest available layer. Now, that's kind of scientific, right? That's a method that is reproducible. Right? You don't have to rely on the authority of some great sheikh. This is just a simple. I mean, you could teach a computer to do fiqh this way. Right? It is a very clear, it's a rational hierarchy of sources that you can use in your legal considerations. So, first of all, Shafi'i's model was systematic, has this scientific attraction. Like you have an opinion and you can trace it to a methodology of how to derive it. It is not bound to local tradition, right? So the problem with local tradition is somebody asking, so why is that relevant for me? If I'm living in the United States, why would I be interested in what the people of Medina do? Right? As a Muslim, I'm Muslim, I'm not Medinan, right? I want to know what is religiously correct. What is some sort of the local flavor of Islamic law is less interesting to me. Right? And the reason why in specifically this point in time, local traditions become problematic is that you have many non-Muslims converting to Islam. So if you imagine you are a descendant of one of the Sahaba, for example, right? Then your sense of tradition is very strong. Right? It's like, okay, my great grandfather knew the Prophet, right? And my family then settled here, and that is their legal environment that has grown up. So that's for me. That's authoritative for me. But if I'm a Rome, like a Byzantine Christian who converted to Islam, I say, well, I want to know, I converted to Islam. I believe that Muhammad was a prophet. I'm not interested in what people do in Egypt or what the local, legal tradition in Kufa was, that's not interesting to me. Give me something systematic. Oh, the theory of a Shafi'i looks interesting. And thirdly, what I call here from local to textual community is that with the rise and spread of books, of book culture, which we have at this time, people start to write books. You have paper available. More and more books are published. People read books. A systematic method of deriving law is much more attractive if you read a text. Right? If you read a text, you don't have the charismatic teacher in front of you. If you read a text, you want it to be more. You are more focused on the consistent argument than if you just attend a teaching circle of a revered figure. Right? There's all this charisma that comes in a direct person-to-person exchange that you don't have if you read something. And what a Shafi'i's method does is it allows people to just to create a textual community. So we all adhere to a specific interpretive method, a specific hierarchy of sources, a specific way of thinking of how law is derived from specific sources. And finally, what a Shafi'i's model really caters to is just the passing of time. Okay, so if you think back at the original thought experiment that I made at the beginning, if you're just living after the lifetime of the Prophet, it is much more understandable that you consider the tradition that you find around yourself to be authentic. Right? These are all the people knew the Prophet, so you just follow what they did. You just imitate what they are doing, and then you'll be following the Prophet. But once you're like 4 or 5 generations removed, and once you know that the practice in one area is different from in another area, and you realize that things have changed, right? That people have that change happens even within traditions, you then start to think, well, we really have to separate here the kind of subjective, local, individual things that have come in and what is actually Islamic law, and how do we do this? And Shafi'i's model is very attractive as a way of thinking about doing this systematically. And so to give you just an example of what happened after Shafi'i. So this is an account of by Abu Bakr al-Athram, who was a student of Ahmed ibn Hanbal. I'm sorry, the slide again messed up a little bit. So this Abu Bakr al-Athram, he attends a teaching circle of al-Buwaiti, who was a student of Shafi'i. So al-Buwaiti is teaching a Shafi'i's legal opinion that ablution in the absence of water, i.e. tayammum, consists of beating the palms of the hands on earth twice, right? Now, at this point, Abu Bakr al-Athram says, there is a reliable transmission by Ammar ibn Yasir that tayammum consists of only one beating. You only have to do it once. So what does al-Buwaiti do? Al-Buwaiti says, but a Shafi'i, who's a great scholar, said, no, he doesn't do that. So he erased 2 beatings from his notes and changed it to 1 on the basis of Ammar's report. Then he said, a Shafi'i said that if you find a reliable report from the Prophet that contradicts my opinion, abandon my opinion and hold to the prophetic tradition, as that is my true opinion. So what we see here is that really this is not a personal school in the sense of, we follow a Shafi'i who is very clever, and we don't know what the reasoning for him was, so we just follow him, taqlid, right? But that his students said, no, part of his method is that his opinions are open to being changed if new evidence comes in. And in fact, he himself said that if you find evidence that contradicts me, go with the evidence, don't go with me, right? So that's why I call this from personal to paradigmatic school. So he established a paradigm, i.e. a method of how to derive law, and adhering to his school is really adhering to his method rather than to his individual opinions, right? And that's why it makes it attractive for specific kind of theory-minded jurists who are interested in both the idea of grounding your legal opinions in revelation rather than individual authorities, but it also is kind of it's consistent, right? Now, the final point I want to make is how influential Shafi'i was on Islamic thought as a whole, right? So Shafi'i is not just important in the formation of a school that is named after him, one of the four schools of Sunni law, the Shafi'i school of law, but he was in fact very important. Like his theorization was so important that everybody else had to position themselves vis-a-vis these ideas. So first of all, his risala on usul al-fiqh, on legal theory, kind of gives rise to a whole discipline that everybody participates in. So it's not just Shafi'is who write on legal theory, i.e. on the methods of how to derive law. But everybody does, not just all Sunni schools of law, all Shiite schools of law start writing on this as well. So it becomes a way in which you justify your law is by showing how it is derived from sources. Right? You have to show this connection. Show me your work. Where does this opinion come from? Right? That is something that a Shafi'i started systematically, and that everybody felt that they had to do the same thing. Right? Secondly, you find an effect of a Shafi'i's work on the Ahl al-Hadith. So Ahmed ibn Hanbal, for example, his definition of the relationship between Sunnah and the Quran is taken from a Shafi'i. So Ahmed ibn Hanbal, partly methodologically, is really taking from a Shafi'i. Furthermore, here I mentioned tafsir. The first tafsir works that have methodological introductions where the authors talk about how they engage in tafsir. How do they explain verses of the Quran, are written by the students of a Shafi'i student. So for example, Tabari, Ibn Abi Hatim al-Razi, these were all people who had studied with the Shafi'i students. And their introductions are really, it's obvious that they're drawing on a Shafi'i's methodology. So the fact that they use, the way they use hadith as windows into understanding what these verses mean, very much influenced and shaped by Shafi'i's theorization of the connection between Sunnah and the Quran. Finally, the Hanafis. I don't want to go too much into detail here. I'm just checking the time. I don't want to go too much into detail here, but the Hanafis also they don't yield to a Shafi'i, but they sharpen their theorization of hadith. They develop this idea of mashhur. So Isa ibn Aban, who is kind of a next generation Hanafi scholar, directly responds to Shafi'i and maintains this distinction that there are certain hadith that you can use in law, and then there are certain hadith that are not mashhur, that you do not use in law. So even those who disagreed with the Shafi'i had to kind of sharpen their methodologies and their terminologies in order to respond to the challenges that a Shafi'i did. So when we think about law, Islamic law today, most people will be affected by Shafi'i's ideas, even if they're not aware of it. And that's what I mean when I talk about a Shafi'i's importance for really Islamic law and Islamic thought overall, even. But the idea that law is something that is done to sources, the Quran and the Sunnah, and then methodologies that we use on these sources. This way of theorizing Islamic law really, to a large extent, was originated by a Shafi'i, living in a specific time period, living about a century after the Prophet Muhammad's death, living at a time when Islamic law as an oral tradition that is taught by individuals, that is applied by judges, becomes a written tradition, becomes more scientific tradition, and thereby becomes a tradition that is open to debate, right? Once you've written your ideas down, people then can read it all over the place, right? You know, I might have opinions about Islamic law that you can read in my book. If I hadn't published this book, you would only know about my opinions if you visited my classroom, right? And I assume most of you would therefore never hear about them. So the fact that Islamic law becomes written down has a transformative effect, because suddenly ideas are spread all over the place, and people can critique them, and people can compare them to others, right? So if you have a book, then you can have several books next to each other and compare them to each other, right, at the same time. With the rise of a written tradition, you have really a rise of a more scientific way of looking at law, and the idea that we're not just dealing with legal traditions, but how can we distinguish between localisms, between changes, between subjective influences, and the law itself, and the law itself coming from the sources. And what are the sources of law? All of this is really theorized with the development of usul al-fiqh, and really Shafi'i being the first one to write a whole monograph on that. I'm not saying that nobody thought about this before, and I'm trying to show in this book also that he's aware and benefiting from all kind of debates that he's having. You know, the Hanafis have thought about the connection between Sunnah and the Quran. The Khawarij have thought about it. He is having debates with Mu'tazila. So he's taking all these experiences and putting them together. And what his view of the law is that it's a practical science, right? He says, I mentioned this in the book, he has a debate with a Mu'tazili opponent. And the Mu'tazili opponent says, well, we need to be absolutely certain for every rule of the law. And the Shafi'i says that's impossible. And you can never do this in law. You know, Shafi'i, he had in earlier days, he had worked as a judge, and he says, you know, we find people guilty, and when we're never 100% sure that they actually are guilty. You know, in the realm of law, there's always it's always just probability, right? And he says we need the Sunnah, and the Quran tells us that we need the Sunnah. And he, again, very convincing. He says, look, the Quran tells us to pray, but it doesn't tell us how to pray. And so it puts an obligation on us to pray, but it doesn't say it how to pray. So that means that we are obligated to consult the Sunnah that tells us how to pray, right? So he says, yes, we can't get 100% certainty about everything, but we have enough probability to engage in this practical affair of law, and he has a methodological solution and theories of how to do this. So that's an overall summary of my book, and I'm looking forward to questions or comments.